Hey guys, sorry I'm late. I was texting. Just kidding. I have 47 unread text messages right now, and I cannot keep up with my stuff today. But I wanted to do this because I saw that David had made kind of an appearance per se, I guess. Since he took his hiatus from everything a couple months ago. I feel like it's been a couple months, right? Um, but I will go through this with you guys. David Gingras, as you know, was charged by the State Bar of Arizona on several counts, several different charges, and he had moved to dismiss the case based on the anti-SLAPP law, and the judge denied that. However, the anti-SLAPP law in Arizona is, I guess, relatively new, so this was a matter of first impression. So he's now taking it to the state Supreme Court to see if they will overturn that. Patrick is actually supposed to be here. He's going to join us. He had to take a shower real quick, so I told him to hurry up. But he will be here to kind of explain some of the legal stuff that's going on in a minute. I'm going to first go over with you guys why his anti-SLAPP motion to dismiss the case was denied, and then we'll read his document that shows him going to the Arizona Supreme Court and asking them to take a look at this. So, I've been very busy today, sorry. Hey guys, let me see. I think I might have this real quick. No, I don't. Okay. All right. So let me look at my summary of this. Okay. So the anti-SLAPP motion to dismiss, right? So he said the State Bar was attempting to discipline him for constitutionally protected speech, and he is entitled to dismissal because they need to protect the First Amendment activity from retaliatory lawsuits. Remember, though, that his protected speech that he's arguing about was bizarre accusations against a judge who was currently presiding over his case. It happened in his capacity as an attorney. It happened in his filings, in his professional law firm blog. I mean, professional is a interesting way to describe that. And so that's questionable because, yes, you have the freedom to speak your mind, right? But at the same time, your employer, right, and these people preside over all the licensed attorneys in the state of Arizona, has a right to fire you. There's no like exemption from consequences from your First Amendment speech, except for the government can't punish you for it. The government can't have you arrested for speech for criticizing the government, that kind of thing. So let me do this real quick. Close that out. There we go. The State Bar is actually accusing David of a lot more than just the criticism of Judge Mata. So they accused him of violating Mata's orders, making public statements that could prejudice pending litigation. That was the speech aspect that he's arguing. Attempting to interfere with witness testimony in the matter of Mike Maricini, making reckless and disparaging statements about the judge, making unprofessional public comments about private citizens. Again, that ties into the speech. Pursuing frivolous claims, presenting false evidence and failing to correct false testimony, dishonesty, fraud, misrepresentation, filing a meritless appeal, and conduct that's prejudicial to the administration of justice. The motion failed because the PDJ gave reasoning centered on constitutional authority, not whether or not his speech was protected. So attorney discipline belongs exclusively to the Arizona Supreme Court. Attorney discipline is not an ordinary civil lawsuit, so the anti-SLAPP statute applies to certain legal actions. Attorney disciplinary proceedings are kind of unique, their own unique type of proceeding. It's not ordinary civil litigation, so even assuming the state could reach regulatory proceedings, applying it here would interfere with the Supreme Court's disciplinary authority. Lawyers voluntarily accept limits on their speech. They take an oath, right? There are rules of professional conduct. Gingras never explained how the statute could coexist with attorney discipline. The PDJ criticized his briefing for asserting that the anti-SLAPP statute supplements the court's disciplinary rules without explaining how they could operate together. At some point, the order states, stating it does not make it so, and the judge found he failed to show that applying the statute would not unduly hamper the Arizona Supreme Court's constitutional authority over lawyers. Okay. The court repeatedly emphasizes that the disciplinary system is an important and necessary function of the Arizona Supreme Court. Attorney discipline cannot be undermined by a legislative enactment, and interpreting the anti-SLAPP statute to allow dismissal of bar complaints would create unnecessary constitutional problems. Okay, so his motion to dismiss under the anti-SLAPP law was denied. Okay. Because this is a question of first impression in Arizona, the PDJ acknowledged that either the state bar or David could seek review by filing a petition for special action with the Arizona Supreme Court. This is what David did. Okay. So let me pull that up for you. One second, guys. Wow, I just muted myself for the last. I just pulled an Omar, dude. Sorry about that. So I was saying before I realized I was muted that I'm not going to take any swipes at David's personal life. I think that that's unnecessary. But I do recall thinking that his behavior during these proceedings and otherwise was kind of erratic, kind of ill-advised, like he wasn't acting in his best interest. And I think it came out when he said that his wife died that he had been dealing with a lot more than most people realized. Now, I think that David is not particularly a fan of mine. He's called me a shit-eating worm, the queen of darkness, etc., and attacked a lot of my loved ones, some of my closest friends, and I don't appreciate that. But at the same time, I'm not interested in kind of trashing the guy outside of like criticizing his behavior in these proceedings. His actual work here, I guess this was filed by Mark Randazza. I don't know how much David had a hand in it or not, but I'm not gonna take cheap shots at David anymore. I think that we've had our backs and forths. He crossed the line several times, but I don't need any sort of retribution. Let's put it that way. I'm ready to just move on. However, if he's doing something legally significant like this, I will talk about it. And I will criticize that, but without crossing a personal line. Okay? Let me run through these real quick, and then we'll start reading this document, and Patrick will jump in here soon. Alan K. Lange, thank you for the 10 joules. Thank you very much. Jill, thank you for the 200 joules. Redondo Beach, thank you for the 10 joules. Oh, thank you again for the 10 joules. And Era CG11, thank you for the 440 joules. Thank you. Thanks, guys. Appreciate that. All right. Lindsay B. Kitty Cat says, wait, this was filed by Mark Randazza, the same Mark Randazza who represents Proud Boys. Does he? Somebody says same Mark. I guess it is. I don't know. Mark Randazza, the only thing I know about Mark Randazza is that he is a free speech absolutist, let's say. And so am I, frankly, but within reason. So, like, I wouldn't, let's say, for example, recently, I think it was in Minnesota, a woman was convicted or found guilty after saying the N-word to a child at a park and then saying the N-word to an adult who was pursuing her after she said that and then, like, continuing to say it. And she was, convicted of, I think it was disorderly conduct. And as a free speech absolutist, it's like even things that are offensive, extremely offensive to me and others, I wouldn't jail someone for that, right? But at the same time, I wouldn't help them. I wouldn't donate to their GoFundMe. Apparently, people have made her a millionaire now, which is insane. I wouldn't support them, but I wouldn't attack their right to speak whatever horrible thing they want to speak either. with the good comes the bad, right? So I think that's kind of where I draw the line, but Mark Randazza seems to just say, you know, he's an absolutist to where he will defend the worst of things. You know what I mean? So there's a difference there between how I feel and how he feels, I guess. All right.
Yo.
What's up?
You can hear me?
Yeah.
Cool. Thanks for waiting for me.
Oh, I started like 10 minutes ago, dude.
Oh, are we live?
Yeah. Oh, sorry. I didn't mean to put that comment up there, but no need to bash. He bought himself a back. Oh, and Doug. Okay, yeah. But I was just about to start reading this document. I probably won't read it word for word or anything. Hey, Omar, what's up? But people were asking if Mark Randazza is the same Mark Randazza who is representing the Charlottesville Proud Boys. So I was explaining that Mark Randazza is definitely a free speech absolutist, and I am also a free speech absolutist, but within certain limits to where I would not represent or support someone who used offensive language like racial slurs and stuff like that, but I also wouldn't advocate for them to go to prison or anything like that.
Yeah.
And then I was talking briefly about that case in Minnesota where the lady was found guilty of disorderly conduct for using the N-word at the park. You seen that?
No, I didn't hear about that.
Really? Yeah, no, it's been going around social media. I guess she said the N-word to a kid, an autistic kid who took like a juice pouch out of her purse or something. And I might be misspeaking there, but that's my understanding of what happened. And then someone else who was at the park, I don't know if they were related to the kid or not, started following her around with a camera, and she started saying N-word, N-word, N-word again. And then she was charged with disorderly conduct and found guilty. And people started to GoFundMe for her, and she got like $1 million from this.
Oh, I do. Yeah, was she like a younger lady with tats?
I don't actually know what she looks like, to be honest. I listened to the video, but I wasn't really paying close attention. You know what I mean? So like, I don't really know if she has tats or not.
Was she white?
Yeah, she was.
Yeah, people will give white women money at the drop of a hat.
Hey.
Hey.
No, I'm just kidding. I don't. I would say like that's the line for me to where I wouldn't support that, and I wouldn't represent that person, and I would not, help them. But I also wouldn't say I want her to go to prison. You know what I mean? Like I don't know.
Yeah.
Anyways,
I don't think anyone should go to prison for words. But
no,
if
she's not going to go to prison. I don't think. I think she has like a suspended sentence or something in like community service.
Yeah, I think that I just think like the moral stigma, like the town square stigma, should be punishment enough,
Yeah. All right. So you have read this, right? The petition for special action.
Oh, no.
You haven't? Okay.
I've skimmed the parts where I wanted to see if he made the argument that I thought he needed to make.
Okay.
And the parts I skimmed, he didn't make the argument that I think he needs to make. So I was kind of like, reading the rest of this is pointless because he doesn't address the worst part of this law for his case.
Okay. Well, this, I guess we're going to go through this, and if it gets too like wordy and we're kind of repetitive, then I won't, read the thing word for word, but let's read the introduction here. It says, this case presents an important constitutional question. May Arizona discipline an attorney for truthful public criticism of a judge on the theory that the First Amendment does not protect lawyers in the same manner as other citizens? And I immediately, in the first statement here, have an issue. Truthful public criticism of a judge. This man has shown no evidence whatsoever that his criticism was truthful.
Yeah, and it's also, this is an introduction, so this isn't even an argument or like it's just pure rhetoric. So including, truth or falsity is a legal determination. So I don't know why it's in here.
Yeah. Omar's talking about that case I was just talking about. Omar, we should do a video about that. Not right now, but later. I'll show it to you. But anyways. This is like she was like, remember, harassing, of course, the judge's father, with trying to subpoena them. It was bizarre because he tried to subpoena the judge at the courthouse a bunch of times. The father, like, he like called him and sent him mail and all kinds of stuff, and like nothing ever came of that. It's just bizarre that he's still trying to say truthful public criticism when, again, there is nothing to back that up. So,
and I think that Jupiter Jane makes a great point about like he wants it both ways. And later on in the introduction, he'll say this was an incredibly high profile case, and yet he wanted things decided on the papers without a hearing because it was such a simple case. I'm like, which, again, it's more of like town square public opinion, but we all know that like this damages your reputation every single time you say one thing and then do another. Like it's damaging, but I just don't think he cares anymore.
This was the comment you were saying. I just don't like how David cries about how he should be allowed to say whatever he wants, but wants to sue anyone who says things he disagrees with. Yeah. Okay.
Yeah.
All right. Anyways,
yes, thank you, chat, for allowing me to shower. I appreciate that.
Dude, it took one line for me to go off on a tangent, but let's try to keep going here. The presiding disciplinary judge answered that question, yes. Accepting the state bar's arguments, the court held the protections of the United States and Arizona constitutions yield to the Arizona rules of professional conduct when the speaker is a licensed attorney. Well, that's to an extent, that's kind of true, though, isn't it?
Yes.
So, all right, if you want to continue to make that argument for them. That conclusion cannot be reconciled with settled constitutional law. For more than 50 years, the United States Supreme Court has consistently held lawyers do not surrender their First Amendment rights upon admission to the bar, subject only to a handful of narrowly defined exceptions that have no application here. And I think the narrowly defined exceptions might have some application here. Interesting.
It's why, like, the way that he tries to characterize what the legal analysis should be is preposterous.
Yeah. Give me 1 second here. I'm gonna.
Yeah, he's like, at some point he's like if it only can, like, speech can only be regulated in these two specific contexts, and that's because the Supreme Court has opined on these two specific contexts, which makes no fucking sense, because how would law ever get created if we had to follow exactly what the Supreme Court said every single time? Like, it just makes no sense.
Omar, I sent you a link if you want to come in. Okay, let's see. Where were we here? The bar's position asked this court to recognize a new class of citizens who enjoy less First Amendment protection solely because they are licensed to practice law. No decision of the United States Supreme Court nor the Arizona Supreme Court supports such a proposition. The decision below threatens not merely petitioners' constitutional rights, but the free speech rights of every attorney in Arizona. But, criticizing a judge, like a random judge online, is not a thing, but criticizing the judge who's presiding over your case, that's an issue, I feel like.
Yeah.
Hey, what's up, Zach? How's it going? Haven't seen you in a minute. Drunkest Turtle, thank you for the 400 jewels. I appreciate that. Jewels are a new thing, I guess, on mobile, but I've been getting a lot of them lately, so I feel shiny.
Yeah, I heard you talking about jewels. I was like, what, jewels?
Yeah. The court should not permit that result, as Justice Gorsuch, is it Gorsuch?
Gorsuch, yeah, good job.
Recently observed, lower court judges may sometimes disagree with this court's decisions, but they are never free to defy them.
That's when I knew David wrote this, because he cited a completely irrelevant opinion that was written like recently, and he just does that.
So this, like, lower court judges may disagree with this court's decision, but they're never free to defy them. That kind of sounds like David, though.
That's what I'm saying. I think this is David. Is David. Yeah. I
disagree with Judge Amada's decision, but he's not free to defy it. So, all right. I think we don't need to go through jurisdiction. Statement of issues, we'll start here. 1, must attorneys surrender their First Amendment and Arizona free speech rights by becoming members of the Arizona bar? And I almost feel like this, I think of it in terms of what I know, right? So healthcare. And I think about the doctors and nurses that I've worked with, and they all agree to certain rules when they get their license. And if they break those rules, they can lose their license. And it doesn't mean they'll go to jail. It doesn't mean they'll be punished in any way, but they will lose their license. So I just kind of look at it that way.
Like, that's such a great example. This just clicked for me. Like, if you're a heart surgeon, right, and you go into your patient's operating room.
Hey, Omar. Go ahead, Patrick.
Hey, folks. Could you hear me? This is an experiment. I don't even know if this is going to work. I'm driving.
Okay. Patrick, go ahead.
But I have a satellite Wi-Fi in my truck. So maybe it'll work. Anyway, you triggered me, and so now I'm here.
I
Good.
triggered you.
Welcome.
What's up, Patrick?
Yeah. What's up, man? I was just saying that like David's bullshit. Well, go ahead. What were you gonna say?
Oh, no, finish your thought, and then I'll add my own after yours.
Okay, yeah. I was just gonna say like, based on the way Lauren was explaining, like just how ridiculous it is that he says like lawyer speech can't be regulated, like this ruling would affect all Arizona lawyers. Like, imagine you're a heart surgeon, you walk into your patient's your patient's room before operation, and you tell them like, hey, I don't think, I think you're probably going to die, on the operating table. Like, doesn't look good for you. And, I heard from this other doctor over here that like, you're probably going to die. Like, yeah. Yes, that is free speech. Like, you can say that, but you better believe that you're going to get like a professional ethics complaint lodged against you as a doctor. And you can probably believe that the, committee that oversees doctors is going to have an issue with the way that you're talking to your patients. Like, it's no different.
Yeah. And I think the general premise is an interesting one, because lawyers should be able to criticize judicial decisions. Honestly, they should. Because otherwise you create this environment where a bad acting judge, not Judge Mono, but a bad acting judge, think of Paul Newman, the verdicts level of bad. If you say anything contrary to his decision or suggest that, it was anything but above board or just lodge a general criticism, can a state bar then allege, you have no First Amendment protection, you have no right to talk about this judge? And the answer to that question is, of course they can, because they're state licensing bodies, and they could do whatever they want, and they can police however they want. But at what point does it become counter to the Constitution? And it's an interesting question. And my thought about all of this was, it's not so much that he criticized the judge, but just going back, and it's hard to even remember all the stuff that happened with Gingras and Judge Mata, but it was the extrajudicial comments that every state bar in California and in Arizona has that says you cannot undermine the faith of the public in the legal community by just saying whatever you want. And so in the comments before I came on, I was like, yeah, it's an interesting question, because a lawyer should be able to have some criticism within reason. Like, for example, think Judge Lyman, like myself and Rachel had criticisms of his 12B6 ruling against Justin Baldoni, and it was based on legal principles, and we just thought that he might have got the law wrong. But it wasn't like attacking her personal integrity or anything.
No, I think that also goes back to like Judge Lyman wasn't presiding over yours or Rachel's cases actively.
Well, that's true, and that's the other thing. But I don't remember every statement that every attorney in that case said. But to the extent that any of them were critical, and and let's be real, when you're in the middle of a litigation with that judge, you're not going to say anything critical to that judge. But when the litigation is over, is the question. Like I've heard plenty of attorneys straight up say, "Look, I think the judge got it wrong. I don't know what the deal was. I think that, for whatever reason, the judge got the facts wrong, or didn't pay attention to this, or didn't pay attention to that." But where Gingras crosses the line is in all of the extra stuff, and I'm not even remembering it all accurately, but a lot of the things that were placed in pleadings, a lot of the things that were placed as personal blogs, I think that's where they're going with it. And ultimately, the intellectual question about what do we do about the First Amendment and lawyers is an interesting one. But I'm not certain that is the crux of David Gingras' appeal going forward, I guess is what I'm trying to say.
Did you say you're using satellite for your audio? Because people are telling me to tell you that your audio is really bad. And I can understand what you're saying, but other people are saying you're cutting in and out and stuff.
I probably am. Like I said, it was an experiment. And if you want me to F off, I will take no offense.
Honestly, try doing it, Omar, not connected to the car's Wi-Fi. Just try doing it on like 5G.
Oh, I'll try. If you lose me, you know what happened then.
Can you take it off and then come back
You
in?
can try to jump back on. I'll just I'm turning off my Wi-Fi. I'm gonna see what happens.
Okay. But I would just want to say before we move on, Omar hit the nail on the head, and that's what I went looking for in this document and could not find, which is from my research on the First Amendment, principles as applied to lawyers facing ethical discipline. They have a constitutional right to disagree with the judge publicly and make comments about a judge publicly after the proceeding has concluded. The clear carve out for when the speech can be regulated is if the speech is disparaging or undermining of the judiciary during the proceeding. David wrote an entire blog post warning the public about Judge Mata while the case was under appeal with the Arizona Court of Appeals. So in my opinion, the case had not closed at that point, and therefore he was still within that window where his speech could be regulated.
Well, he said, "Look at me, daddy," while seeking a change of judge. The "look at me, daddy" thing.
Yes.
She was
So
still presiding judge.
Was that during that was during the family law case that he said that?
Yeah.
Are you guys hearing me better or no?
No, it's worse.
Yeah. Well, look, no, it's a good point. It's inside or outside of the proceedings. The truth is that the First Amendment, as it pertains to lawyers, professionals in general, anything that has a general licensing body, there's different rules. Like you can do whatever you want in terms of the United States Constitution, and we protect free speech. But even free speech is not 100% protected. For example, hate speech in most circumstances is protected. You can literally burn the American flag without penalty, right? Or that used to be the law. I don't know what the laws are anymore with Trump and the way that's enforced. But the way that we understand it is hate speech is protected. But what you arguably cannot do, which is what I was disagreeing with you with in the comments of what triggered me, was walk up to an autistic kid and call him the N-word and then call his parents the N-word. And if you think that your life is not in peril, then you just grew up in some different places than I. Because the reality of that scenario, it's the equivalent to me of yelling fire in a crowded theater, which the Supreme Court has overwhelmingly ruled that is not protected speech. And so there's limits to this free speech thing. You don't just get to say whatever you want. And this idea, and my understanding from what the Arizona courts are saying, is that, but you have, I think the language they used was you have a diminished First Amendment protection as a lawyer. And I think that's poorly worded. Because the reality is, you have the right to say whatever you want, but we have the right to conduct our legal system, licensing body the way that we see fit. And in our opinion, from the Arizona State Licensing Body and the State Bar of Arizona, that speech is not going to be protected by this licensing body. And it is our right, it is our constitutional right to discipline you accordingly. And I think that that's where the fight is.
Just circling back really quick to Bruce's comment here. It says, don't forget his YouTube video where he was complaining about the judge and waving his gun around. I don't think it was brought up on the state bar, but I remember that for sure.
There's a lot. There's a lot that's out there, and I don't know what is actually being litigated. I guess is where I'm being cautious. It's just that, look, the general premise, like I said, it's an interesting one. And is it Supreme Court worthy? I guess we're going to find out. But to be clear, this is Arizona Supreme Court, right? It's not like the United States. Like, we're not there yet, correct?
Yeah.
Somebody had sent me a text message like, this is going to the Supreme Court. I was like, it is? It's like, oh, this Arizona. No, it's not. It's not there. We're not quite there.
And then it'd have to go to
a little ways to go.
It'd have to go to the ninth Circuit?
Yes.
Yeah.
All right. Let me. I'm going to read 3 and 4 here. It says, "Did the presiding disciplinary judge err by granting judgment on the pleadings when the material facts were disputed, and by applying an erroneous legal conclusion that the First Amendment and Arizona constitutional protections for free speech do not apply to lawyers? And 4, does Arizona's newly expanded anti-SLAPP law apply in attorney discipline proceedings? And if so, does it unduly hamper this court's authority to regulate the practice of law in Arizona and therefore violate separation of powers principles?"
So in law school, we have to write these appellate briefs as part of like our legal writing class. And I would give, and characterizing your issues is really difficult. But I'd give his characterization like a C.
Okay. All right. Moving into the statement of
I would have given it like a B. That's kind of mean, Patrick.
Four was fine, but 5 was just a falsehood and rhetoric. So that's why I gave him the C.
Well, to the extent that I literally zoned out and didn't hear the full thing, I'll defer to you.
Nice.
All right. This attorney discipline proceeding arises from the respondent, State Bar of Arizona's attempt to discipline David Gingras for, among other things, his truthful public criticism of a superior court judge, his petitioning activities, and other speech relating to matters of substantial public concern. Mr. Gingras has been licensed to practice law in Arizona since 2004. The disciplinary charges stem from petitioner's representation of a party in Laura Owens v. Clayton Echard, a highly publicized Maricopa County family court proceeding because the case involved a former TV star of The Bachelor and extraordinary allegations of fabricated pregnancy. It attracted widespread public attention, extensive social media coverage, and live-streamed court proceedings. Whoops. Following trial, the Superior Court ruled against Ms. Owens, awarded approximately $150,000 in attorney's fees against her, and referred the matter for criminal investigation. Mr. Gingras was not accused of participating in or having knowledge of any alleged criminal conduct. Well, they did say that he allowed her to use false evidence, basically.
Yeah, it's an unnecessary sentence.
Yeah. During and after the litigation, Mr. Gingras engaged in several forms of speech and petitioning activity that later became the subject of disciplinary charges. This included criticism of the trial judge, communications with law enforcement. That's when he called the cops on Mike Maricini, I believe, and private communications unrelated to the practice of law. This is probably related to the Reddit stuff, right? The State Bar alleges these statements violated the rules of professional conduct. Mr. Gingras maintains his statements were either factually true, constitutionally protected opinion, or otherwise protected by the First Amendment, the Arizona Constitution, and Arizona's anti-SLAPP statute. A principal focus of the disciplinary proceeding concerns petitioner's public criticism of the trial judge and Owens. That criticism arose after petitioner discovered information suggesting the trial court relied upon facts never introduced into evidence and considered material originating outside the trial record. Okay, so this was the Planned Parenthood closed on Sunday thing, I'm guessing?
Yeah.
Yeah. Okay. Based upon the trial transcript and other evidence, petitioner filed a verified notice of change of judge for cause, setting forth the factual basis for his concerns. Okay, setting forth the factual basis for his concerns is putting it lightly. He actually insulted the judge, said that she was just performing for her father, suggested she participated in things that are for a judge not legal for her to do within her job. So like that's
I'm wondering if this Exhibit 17 is the look at me daddy, because if it is, what a wild thing to put in your the first couple of pages of your brief.
It won't let me open it up. Yeah.
I'm sure he regrets putting that now. I mean, after the fact, but if they ever write a brief on this and, decide this on its merits, it's going to be really interesting because the question that they're asking is, how far can you go in your criticisms of a judge when your aim is to raise your concerns in the litigation? What's the extent? That's the question that we're asking, right? And so to the extent that they actually rule on that in the merits, they're gonna have to define it. I'd assume.
Yeah.
And it's going to become a measure of some kind of law over there in Arizona in terms of an attorney's ability to speak extrajudicial statements into the public honosphere.
That's why I think it was such a stupid idea for him to file this, because he could potentially hurt other lawyers in Arizona because his facts are bad enough that it could justify regulating lawyer speech.
It could, well, I disagree because of this. Most lawyers would never speak the way that Gingras spoke about Judge Mata. Ever. Ever, ever, ever. Like we were taught in law school, you don't do that. Like I was taught at the DA's office, you don't do that. Like, look, they call balls and strikes and you got to live with the decisions. We were taught to respect. We were taught to, most attorneys are taught to fear judges. And so if we get this definition from the Arizona Supreme Court that states that, look, certain statements are fine, this is where the line is, it could potentially have the opposite effect. We're saying, wait a minute, so I am allowed to speak my mind when it comes to certain things, if they rule a certain way, right? Because there's a good chance that they're just going to say that, the Arizona State Bar is perfectly within their purview to decide what they deem inappropriate or what isn't. But if they define a pocket of space for attorneys to openly criticize judicial decisions or judges in general, well, then that's just open up a can. And I don't know what the ramifications of that would be, but it's going to go a long way beyond the judging robe or whatever that website is, where lawyers basically do the same thing. They just do it anonymously. The roving room, that's what it was.
Yeah, 17 here is the notice of change of judge for cause, so that is what they're citing there.
Okay, I'm gonna find it.
Okay. Okay.
Hey, folks, I'm gonna dip out because I'm about to walk in the house. But thanks for letting me on and rant for a little bit. Anyway.
Yeah. Thanks for coming in.
Yeah, nice to hear from you.
All right. See you later.
Hey, I love you both. You guys take care. Bye-bye.
Thanks, you too. Bye.
Bye. Okay. After petitioner filed his answer asserting that the challenged speech was protected by the United States and Arizona constitutions, the state bar moved for partial judgment on the pleadings. The bar acknowledged factual disputes existed, but argued they were legally irrelevant because constitutional free speech protections are not a valid defense in attorney disciplinary proceedings. Petitioner filed a lengthy brief opposing the motion.
Yep, it's in here. Fucking idiot.
Mm-hmm.
No, I'm sorry. I found it. Yeah, he did put the "look at me, daddy."
Yeah. And guys, I'm sorry. I know Omar's audio is bad, but hopefully you guys can understand what he was saying. I could understand what he was saying. It was just crackly, which is kind of funny because Omar's voice is so soothing, and people are always like, "Oh my God, Omar's voice!" And then now he's like, "Crackle."
I know. That was tragic for Omar's what's it called? Night podcasting brand.
Right. He tried his best for us, guys. He tried his best for us.
I mean, the fact that you have two attorneys on this, like,
Mm-hmm.
I mean, that's special in and of itself. Not that I'm special. I'm just saying that, like,
Are you an attorney?
Honestly, sometimes I don't know.
I thought you were a massage therapist. My bad.
I think I'm just like a full-time dog sitter. Look at this thing.
Right. Oh my God, he's got pajamas on. That's crazy.
She got her jams on.
Yeah. All right. Anyways. All right. The presiding disciplinary judge granted the bar's motion in part, holding petitioner's constitutional defenses failed as a matter of law. Petitioner later moved to dismiss under the anti-SLAPP statute. The court denied that motion, concluding constitutional protections for speech did not bar attorney discipline, and further concluding Arizona's anti-SLAPP statute could not be applied in disciplinary proceedings because it would unduly interfere with this court's authority to regulate the practice of law. The court expressly recognized that its interpretation of Arizona anti-SLAPP statute presented an issue of first impression that could warrant special action review, which is what we're looking at now. So this here, it would unduly interfere with this court's authority to regulate the practice of law. And I feel like that applies to, like I said, any sort of board where people are held accountable with their license and rules that are set, standards that are set. It's like the law shouldn't interfere with your employer or the person issuing your license, their ability to regulate your conduct if you agree to certain conduct when you accept your license. So I don't know. Maybe he could be like a court TV analyst and he can say whatever the fuck he wants. However, as a licensed attorney, you're bound by certain standards that you agreed to when you took your oath.
Well, whenever you're talking about the First Amendment, the standard of review is strict scrutiny. So the question is the law at issue narrowly tailored to protect a compelling interest? Mm-hmm. And I mean, what he's essentially saying is that the entire canon of Arizona ethics law violates the First Amendment. And so it's just conclusory. It's just lazy. It's just annoying.
Yeah. All right. Petitioner
That's my thing is like these are his facts. Like
Yeah.
he needs to wrestle with these facts, apply the facts to the law, not these lofty statements that sound good on paper, but they don't move the needle in any analytical direction.
Yeah. Well, you could move the needle to the left by putting "Look at Me, Daddy" in here.
Yeah, he certainly did that. He definitely put it all the way to the left.
Oh my God. All right. Petitioner now seeks special action relief because the rulings below hold as a matter of law that the First Amendment and Arizona Constitution do not protect the speech at issue, and because those rulings present recurring constitutional questions of statewide importance. All right. Special action review is particularly appropriate in free speech cases like this one. And I guess he's just arguing that the review by the Arizona Supreme Court is appropriate. Is that what we're looking at here?
This is all about why it's proper for him to bring up a special action.
I don't think we need to look at that really. I mean, I agree, being that this is like a matter of first impression and all that, and it's First Amendment issue, that's appropriate. But I don't agree that he should win the case. Let's put it that way. But like, I don't think we really need to read that.
Yeah, I don't need to know the standards for special action. Like,
I mean, it sounds
he's
like
already filing the special action.
He meets the standard. Just the judge even wrote in there, the PDJ even wrote in there that he meets the standard for special action. So that's not really something I need to look at. The PDJ erred by granting judgment on the pleadings. Let's see. The PDJ granted the bar's motion for judgment on the pleadings partially based upon a single flawed legal premise that petitioner's First Amendment and Arizona constitutional defenses failed as a matter of law because attorneys do not enjoy the same constitutional protection for free speech as other citizens. And I'm trying to think back to when that judgment on the pleadings motion was filed. I feel like this isn't all there is to it, and I can't remember.
That's why I'm like, why would you not quote the actual holding? And he doesn't even cite to it. It's just so fucking lazy.
Well, it kind of sounds like I feel like he's leaving something out. I'm trying to remember why they granted that partially.
I'm doing his work for him again.
Right, yeah.
I'm looking it up.
Okay, while you do that, I'm going to keep reading. That legal premise is contrary to controlling authority from the United States Supreme Court and cannot support judgment on the pleadings. Moreover, even apart from that constitutional error, judgment on the pleadings was independently improper because petitioner's answer denied essential factual allegations and asserted legally cognizable defenses. Under settled Rule 12c principles, those disputed factual issues require denial of the bar's motion. So I vaguely remember the bar arguing that the substance of like what he was saying didn't matter. It was a matter of law that he couldn't do that. And I'm trying to remember what it was. I don't know if you're pulling it up now or if you want me to do it. I will.
Victims of Laura Owens UI is all messed up, but I found it.
Okay. Yeah.
And I will always. What was the question? What was the question?
What were they? So they were asking for judgment on the pleadings based on what? Because it was a matter of law, not a matter of fact, right? That they asked for the judgment, the partial judgment on the pleadings. What was the issue that they were?
Okay, got it.
Like, why was that granted? I guess.
In the motion, the state bar seeks judgment on a portion of the pleadings for one, Gingras violated Judge Mata's order in violation of a certain rule, not to share evidence, and two, respondents' comments about Judge Mata were made in violation of a bunch of rules.
Okay, so the first part they did not get granted, right? It was the second part they got granted, so that makes sense.
Yes, that makes sense. Yes.
So the first part with the violated rules, the judge did not grant that. Okay.
Yes, that's right.
Right. Okay. So this all makes sense now. Right.
Didn't grant it because there was a legitimate question of fact.
Right. Exactly. Okay. Moreover, even apart from that constitutional error, judgment on the pleadings was independently improper. Okay. Let's see. Under settled rules, factual issues required denial of the bar's motion. Let's see. The bar was not entitled to judgment on the pleadings. A motion for judgment on the pleadings tests only the legal sufficiency of the pleadings, not the evidence. Well, that is what happened. So. The court must accept the non-moving party's well-pleaded factual allegations as true, right? construe all reasonable inferences in that party's favor, and deny the motion whenever material factual disputes exist or the answer asserts a legally sufficient defense. Okay. Those standards were not satisfied here. In what way? Petitioner's answer admitted making certain statements concerning the trial judge in Owens, okay, but expressly denied that any statements were false or made with reckless disregard for the truth. Okay.
Oh, yeah. He thought that this was so clever. He's like, if you read my answer, not once did I admit to anything. And we were like, oh, okay. And the judge.
Didn't he, though? Like, I remember he, like, it seemed like he was manic posting when he filed his stuff. It was like he was like manic blog posting or something. I was like, why would you say that?
This is from the PDJ's ruling. Mr.
Right.
Gingras did not challenge the state bar's indication of his admissions regarding paragraphs 101, 103, 107 of the complaint. Rather, he focuses his response specifically to what he describes as speech outside the courtroom, making no distinction between statements made in motions before the court and those on social media. Regardless, Mr. Gingras seems to argue that Gentile is controlling and supports his proposition that disciplinary rules governing the legal profession cannot punish activity protected by the First Amendment, blah, blah, blah.
Mm-hmm. Okay. Can you put that in English for me?
He's going to talk about Gentile here. He's going to make the exact same argument that he made to the PDJ. Okay. This is David's special.
All right. Okay. The answer further alleged that the challenge statements were either factually true, constitutionally protected opinion, or made with a good faith factual basis to believe they were true. What? Okay. Formed after a reasonable investigation. Okay. There was no reasonable investigation, though. It was like he looked at some YouTube videos and posted some clips of other people's YouTube videos and was like, I believe this random person standing outside who I have basically called a crazy member of a cult who is untrustworthy is now telling the truth, so I'm going to go ahead and disparage the judge currently presiding over my case. That doesn't really make sense. All right.
And again, that's a question of fact. This is a court of law. Like the Supreme Court doesn't adjudicate facts.
Right. Okay. Those allegations alone created disputed issues of material fact, like you said, material fact, and asserted factually valid constitutional defenses. Okay, but even if those things were true, still, okay. Accepting those allegations as true, as Rule 12c required, the bar was not entitled to judgment as a matter of law. A plaintiff's motion for judgment on the pleading should be denied where issues of fact are properly raised by the answer. Okay. The PDJ nevertheless granted the motion because she concluded those factual disputes were legally irrelevant because, in short, truth is not a defense. Wait, what? PDJ nevertheless granted the motion because she concluded the factual disputes were legally irrelevant because the truth is not a defense. I don't think she said that. According to the PDJ, even entirely truthful criticism of a judge may be disciplined because attorneys do not possess the same constitutional protections for speech as other citizens. That legal conclusion is incorrect. Dude, nothing in the world shows that this was entirely truthful criticism of a judge. Quite the opposite, actually. It's oh my God. Okay. That's delusional. The PDJ's, what's up?
This is what David does. He doesn't read things in the first instance. He doesn't read things. In the first instance, he doesn't read things. I didn't realize my camera's off. In the first instance, he doesn't read things when they come out. He skims them, as we saw by the fact that he filed an amendment to one of his pleadings after Bruce and I lit him up. But second of all, he clearly doesn't go back and revisit the pleadings either. So, like, I'm looking at the PDJ's findings right here. So far, he has not correctly characterized anything the PDJ has said.
No, this is like sarcastic, like half-truth bullshit that I'm reading.
I'm going to put in the chat, in case anyone wants it, a copy of the PDJ's decision if you guys want to multitask.
All right. The PDJ's constitutional analysis conflicts with controlling Supreme Court precedent. My bad. The state bar's primary position is that the attorneys surrender their First Amendment rights upon admission to the bar. Over the last 50 years, the United States Supreme Court has never approved that argument. Well, that's not exactly what they're saying here. I mean, you still have your right to free speech or whatever, but if you're actively, performing as a lawyer and you sort of put doubt in the judicial process based on your criticism of the presiding judge over your case, and the public starts to question that, that's a problem. Over the last 50 years, the United States Supreme Court has never approved that argument. To the contrary, each time the same or similar issue has arisen, the Supreme Court has rejected it.
Oh, it's just a straw man argument.
Yeah. In Baird versus the State Bar of Arizona, the court held Arizona could not condition admission to the practice of law upon surrendering First Amendment freedoms. I don't know that one. In Bates versus State Bar, the court likewise recognized that attorney disciplinary rules remain subject to the First Amendment. Okay. In Gentile versus the State Bar of Nevada, the Supreme Court rejected the argument that attorney speech receives diminished constitutional protection simply because the speaker is a lawyer. Okay. Well, I think we're leaving some stuff out here. Like, a lot of this stuff, this free speech stuff, probably didn't occur within the context of their job.
Yeah, there's a ton of context missing from
Right.
that makes it distinguishable.
Mm-hmm. Yeah.
I wonder if he's going to bring up the Martinez case, because that one is from Arizona and is what the PDJ seems to have relied on.
Guess we'll find out.
Let me read this real quick. The PDJ disagrees with him regarding Gentile. The PDJ says, in Gentile, the subject lawyer held a press conference in which the Nevada court found he knew or reasonably should have known to have substantial likelihood of materially prejudicing an adjudicative proceeding. Wow, that was a mouthful. The Supreme Court found that the Nevada rule was void for vagueness. The court went on to state, moreover, this court's decision dealing with lawyers' First Amendment rights to solicit business and advertise have not suggested that lawyers are protected to the same extent as those engaged in other businesses, but have balanced the state's interest in regulating a specialized, this is the balancing test, the narrowly tailoring, have balanced the state's compelling interest in regulating a specialized profession against the lawyer's First Amendment interest in the kind of speech at issue. So it's a balancing test. David is saying Gentile stands for the proposition that if the only way speech can be regulated is if the speech relates to commercial activity. And the PDJ has already said, no, that's not the analysis. The analysis is, okay, the speech is the speech being regulated, are the interests balanced such that there's more of an interest in protecting the public by regulating the speech than there is in allowing the speech. So in the commercial context, the interest is they want to regulate lawyers' speech for commercial activities. And the way that they're doing that is by implementing ethical rules that say, how you have to, behave when you're making commercial statements. That has nothing to do with what David did.
Okay. So I'm going to skim over this part then. He says the same rule applies here. Petitioner's speech involved public criticism of judicial conduct and other matters of public concern, not attorney advertising and not confidential litigation information. Consequently, the ordinary protections of the First Amendment apply just like they did in Gentile. And I think you just kind of went over that. So, right. Indeed, courts throughout the country recognize the same principle. We'll look at what he cited here in case you recognize anything. Henry Green, Standing Committee versus Yagman. Yeah, I don't know. This is all kind of saying the same thing. In Olin, but it lacks the necessary context, I think.
Okay, this is what the PDJ said about Green. Mr. Gingras asked the PDJ to consider other jurisdiction findings regarding his proposition, citing In re Green. In the In re Green case out of Colorado, the subject lawyer's criticism was based upon fully disclosed and uncontested facts, and thus the attorney could not be disciplined for making the statements. Mm-hmm. Even if such could be considered persuasive authority in the instant matter, other courts have declined to follow In re Green as well. And then they cite to, additionally, Mr. Gingras submitted a newly decided U.S. Supreme Court case regarding a law banning certain types of therapy. Full citation was not provided. For multiple reasons, this is not a controlling or persuasive authority.
Which case was that with the therapy? I can't remember.
Chiles versus Salazar?
Okay. I remember him doing that. And I was thinking, like, this is super irrelevant. But okay.
Does he cite Marshall here? No. You know what David is really doing is, and it's not a bad strategy, but he's banking on the Arizona whatever bar on their laziness, because I do have to say that their brief was pretty lazy. They were basically just like, yeah, anti-SLAPP shouldn't apply because that would suck for us, and like that's not the case. So I mean, if David is, this is how he litigates. He banks on the other party's weakness or laziness, and it's gotten him pretty far. So we'll see what the bar brings to the court.
All right. Well, he says Olin here in Olin, the First Amendment does not protect intentionally false statements and false statements made with reckless disregard for the truth. Truth is an absolute defense to any statement made by an attorney that impugns the honesty or integrity of a judge. However, what he said was not truth.
That wasn't cited in the PDJ's decision. Neither was Anderson.
Okay.
That's a bankruptcy court? Oh my God, maybe that's a little Freudian slip right there. Do you see that?
Wait a minute. Hold on. What?
No. Sorry. Cal State Bar Court reporter. Sorry, I thought it said it was a bankruptcy decision. I was like, shit.
Okay. Against this vast weight of authority, the state bar argued the PDJ agreed that lawyers do not have the same or any free speech protection, or any is putting it a step far. According to the bar, this conclusion was implicitly or explicitly supported by in re matter of James Lawrence Riley. I don't know if you know that one.
Riley?
Correct. Yeah, Riley.
Is it R-I-E?
R-I-L-E-Y.
Yeah, it's here.
Okay. Riley involved alleged misconduct by a former prosecutor who later was elected judge involving comments he made during his campaign. Okay. They said a lawyer is held to a narrower standard of free speech than a non-lawyer when discussing the judiciary. This court further quoted that 1957 Missouri decision for the idea that a layman may pursue his theories of free speech or political activities until he runs afoul of the penalties of libel or slander. Well, that's where David has a problem, I think. Or into some infraction of our statutory law. A member of the bar can and will be stopped at the point where he infringes our canon of ethics, and if he wishes to remain a member of the bar, he will conduct himself in accordance therewith. How is that helpful to him?
Could you read a little slower? Sorry, or I can read it.
Yeah, this one here. Okay, I feel like that's an argument against him. So why is he citing that?
The court further quoted that 1957 Missouri decision for the idea that a layman may perhaps pursue his theories of free speech or political activities until he runs afoul of the penalties of libel or slander, or into some infraction of our statutory law. A member of the bar can and will be stopped at the point where he infringes our canon of ethics, and if he wishes to remain a member of the bar, will conduct. Yeah, that is. Oh, but I mean, Riley was cited by the Arizona bar, like in their argument for why David should be disciplined. So maybe that's why it's unfavorable to him.
Okay. These passing comments from Riley and Woodward were harshly criticized in a dissent by the Chief Justice, who warned they were inconsistent with both the First Amendment and the Arizona Constitution. Okay.
This is him trying to, make himself like buddy up to the court by flattering them.
Do you want to read this part here?
No.
This block quote?
Oh, sure, I can, but I don't think it's necessary. But yes, I can. So what the dissent said was the broad sweeping generalities of these statements cast serious doubt on their constitutionality in view of the First Amendment. and the Arizona Constitution. If the court's opinion had limited itself to statements by the lawyer candidate which were false, misleading, or concerning pending litigation, I could have joined in that portion of the opinion. The holding that a lawyer as a candidate for judge may not criticize the decisions of a sitting judge, however, is neither in harmony with the First Amendment nor with the necessities of a free society.
Okay.
Yeah, that's. I mean, I don't know the Riley case in and out, but I'm pretty sure it was a lawyer who was running for judicial office, and while they were running for judicial office, made disparaging comments about a judge, and it was a rather complicated case because they had to discuss judicial canon ethics and lawyer ethics. So it was a pretty complicated case, and I'm not sure what standard the court applied here. Did they apply the judicial canon standard, or did they apply the lawyer ethics standard? I'm not sure.
Okay. Let me read these real quick. Wallace Juno, thank you for the $5 money towards more dog jammies. I'm going to get my dog some now, I guess. Jules and MN chilling, thank you for the $2. My fee for being late and going to beginning. Oh, God, she's going to have to sit through Omar's crackling. Oh, well. Let's see. We're going to skim through the rest of the Riley stuff, I think. Okay, the conclusion was yet again reaffirmed earlier this year by Childs v. Salazar.
He brought up Salazar again?
Yeah.
After the judge said that this is wholly irrelevant?
Yeah. There, the Supreme Court rejected the bar's argument that licensed professionals do not have the same free speech rights as others.
Oh, David.
Yeah. The Constitution does not protect the right of someone to speak freely. It protects the right of all. Okay. It safeguards not only popular ideas, it secures even and especially the right to voice dissenting views. Consistent with these principles, our precedents have expressly rejected the notion that professional speech represents some separate category of speech subject to diminished constitutional protection. So why did the judge say this was wholly irrelevant?
Yeah. So I'm pretty sure, in my opinion, the PDJ decision was written with the understanding that it was going to be special actioned. So it was written broadly without a lot of commitment or analysis. But the only thing that was said about Salazar was in a footnote. And the footnote just says, Gingras submitted a newly decided SCOTUS case banning certain types of therapy.
Oh, this was the therapy case. Okay.
Yeah. For multiple reasons, this is not controlling or persuasive authority. I mean, if you're going to dismiss a case being cited and just say for multiple reasons, I don't know. I mean, obviously, this person is a judge. They should be given the benefit of the doubt that they have their reasons, that even if they're not stated. But is the Arizona Supreme Court going to love that? Probably not.
Okay. All right, let's see. In its dispositive motion, the bar never discussed any of this authority, nor did it explain why this case should be governed by 1957 legal standards rather than more recent Arizona and U.S. Supreme Court authority. All right.
No, the PDJ did rely on a recent case, Martinez from 2020, literally right here in the PDJ's decision. Our Supreme Court has found within the last 6 years that the rules of legal ethics is not merely aspirational. In Ray Martinez, 2020. Diligent and competent representation of a client does not require or justify denigrating, disrespectful, belittling language.
No, I'm pretty sure this is all based on 1957. Okay.
It's fucking ridiculous, David. I mean, it just makes part of me thinks it's also like his way of like twisting the knife for on what's the guy's name? That poor the guy Ian. What's the guy's name? The guy who's prosecuting him?
Oh, Jim Lee.
Jim, yeah, Jim. This could be another way to twist the knife on Jim, knowing like, he's got to respond. He's got to clean up my mess.
He says here the PDJ misunderstood and misapplied genteel. Accurately stated, genteel stands for the opposite premise cited by the PDJ. Attorney speech is not subject to greater regulation than speech by others unless the speech falls into one of two categories, either commercial speech by attorneys or restrictions upon release of information that the attorney could gain only by use of the court's discovery process. Neither of those categories applied here, so Mr. Gingras' speech was, like in genteel, entitled to a full constitutional protection. The PDJ's contrary holding misapplied genteel and must be reversed. Okay. Because the PDJ applied an incorrect constitutional standard, judgment on the pleadings must be reversed. Okay. I mean, this is based on the same stuff, so I'm not going to read through all that. All right. Number 3, attorneys do not surrender their First Amendment or Arizona constitutional free speech rights upon admission to the bar. Okay. Here, the state bar argued, and the presiding disciplinary judge agreed, that an attorney's admission to the practice of law constitutes an agreement to accept restrictions on constitutional speech rights that would not apply to other citizens. The PDJ made that point clear. It says a person is not required to practice law in Arizona. However, once one elects to do so upon admission, the person has agreed upon these directives in the rules of professional conduct and restrictions on one's general personal rights. I mean, that is kind of basic understanding of, you know, having a career where you answer to a licensing board, no? That seems kind of basic. You have to abide by the rules of professional conduct. That's not like that's not rocket science. Nor is it unconstitutional, in my opinion. But
I don't even understand the point of quoting this.
I don't either. But so they're saying that the attorneys do not surrender their First Amendment rights upon admission at the bar, and then here the PDJ,
oh yeah, well the state bar did fuck up that part of the argument. I mean the state bar's brief sucked. It sucked. It's just so fucking lazy. Like, just fucking do your job, bro. Like, or pay them more. I don't know. One or the other.
All right. Okay. Well, this is the PDJ said, I guess, the person is not required to practice law in Arizona, but once they elect to do so, they agree upon the rules of professional conduct, I guess.
Yeah. That's not like saying, like, you know, when you, like, if I apply to get my driver's license, I don't relinquish my right to due process because I have to stop at a traffic light.
Right. But if you don't stop at the traffic light, you get a ticket.
And you lose your license.
Right. Exactly. Yeah. I don't think that's like rocket science. I don't think that they're. I think that's pretty basic understanding. Like you shouldn't do what he did, basically.
I don't give up my Fourth Amendment rights because I have a driver's license. You know what I mean? Right. Like, just like I don't give up my First Amendment rights because I'm a lawyer. Like. Mm-hmm. You know, if I had an active case right now and I was talking shit about the opposing party and the judge right now, my speech can be regulated because my speech is affecting an ongoing court proceeding, which the bar has an interest in protecting the integrity of.
Mm-hmm. Okay.
It's not rocket science. Like, it's just
no. No. All right. Let's see. Got down there.
You know, by the way, Section 5, he actually asked for, or Section 6, he actually asked for the case to be reassigned. So I think he's gonna throw a little shade at the PDJ.
Oh boy. Okay. Well, I don't think we need to read much beyond that on that point, so we'll keep going down here. Right.
I was so much less angry before David came back.
For the PDJ erred by ignoring the greater protection provided by the Arizona Constitution Speak Freely clause. Okay, so this part of the Arizona Constitution, the Speak Freely clause. Okay, so
yeah. So a way to explain this to people, and I don't know Arizona law, so but I am licensed in Florida, and so obviously we have a federal constitution, and then each of our states has its own constitution, yeah. And the state constitutions have to be at least cover at least as much information as the federal constitution, but it can cover more things. So like in Virginia, like the right to vote by mail is actually in their constitution. Crazy. And in Florida, having a disability is actually viewed as like a protected class. So I think what David is probably going to say here is that the Arizona Constitution is more lenient in terms, or more favorable in terms of First Amendment protections than the federal Constitution.
Okay. Let's see. Arizona Speak. I'm just trying to skim some. Arizona Speak Freely clause is not merely a duplicate of the First Amendment. This court has repeatedly recognized that Article 2, Section 6, which is the Speak Freely, may provide broader protection for speech than the federal Constitution. Just a few weeks ago, this court reaffirmed. So this was like recent. Okay. Just a few weeks ago, this court reaffirmed the Speak Freely clause tolerates no censorship or restraint on protected speech except as permitted by the Constitution itself, and emphasizing Arizona's longstanding commitment to robust protection of expressive rights. Okay. Whether this ultimately affords broader protection than the First Amendment under the particular facts presented here is a question this court need not resolve at this stage. The dispositive point is narrower. Petitioner's answer expressly raised the Arizona Constitution as an independent defense, yet neither the state bar nor the PDJ analyzed that defense or explained why it failed as a matter of law. The issue was simply not discussed at all. Okay.
Hold on. So far, what I haven't heard David say, and I don't have the PDJ's decision on the anti-SLAPP in front of me, but I'm going to look now. But I'm almost positive that the PDJ didn't even reach the anti-SLAPP issue because she said he didn't like. Remember, I was telling you yesterday about opening the door and walking through the door,
right?
And I said the PDJs didn't even find that David opened the door. Mm-hmm. And if David hasn't addressed that, then yeah, this may actually not get granted because it's not responsive to the issue.
What? Okay, so what is the issue that he would need to address to open the door?
Yeah, let me look that up.
Okay. All right. Let me read this last paragraph here. Accordingly, even if the court were to conclude the petitioner's federal constitutional defense presented a close question, the unresolved defense under Arizona Speak Freely clause independently precluded judgment on the pleadings. The order granting partial judgment on the pleadings, therefore, should be reversed. Okay. And then we go down to 5. I'll give you a second. I'm going to read this real quick. Buffy Lynn, thank you for the 100 joules. I appreciate that. All right. I'm going to go through some of these comments while you look that up. Bruce's antlers were vasectomized. What? Okay. Sorry, not to distract you.
I wish the Volo website. Oh, there it was. It's the UI is all messed up.
What are you looking for? I can probably send a link.
Oh, I somehow I figured it out. Okay. Oh wow, Laura looks rough. Sorry, that was like that scene in Obsession where she's like in the corner of the room.
Alif 79 Ali F, sorry, 7903, just like you cannot as a nurse or doctor come to work high off legally prescribed medications. I mean, there are rules, yeah. Okay. Patrick, great point. This seems unresponsive. He's arguing free speech, not if the board can regulate his license based on speech. Okay, got it.
Yeah.
TX Packet says same with law enforcement. Yeah. Yeah. I mean, most people are subject to certain rules with their job. I know if I went on social media and I started mouthing off about the clients that we have, or I started mouthing off about the insurance companies that we work with, I would probably be fired, right? I would probably be blacklisted from any similar job. So there are consequences, of course, to speech sometimes, especially in the context of your job. There are certain things you can't do. A reasonable person knows you can't act that way, or you're going to face consequences. And this is, to me, is just kind of stamping your feet after facing those consequences. And like you had to know that was a bad idea when you did it. But of course, here we are. Oh my God. I'm sorry. I just got the picture you sent me of you in the shower cap.
I was being sassy because you were like, hurry up. I was like, this is literally my life right now.
Sorry. Who wants to see Patrick in a shower cap? I'm not going to show it. I won't show anybody.
It's not cute, promise. Okay, so I'm having a hard time finding it because so much paper got filed in this thing.
Yeah, it was a lot.
I'm looking.
What exactly are you looking for?
I am looking for, the judge asked David and the bar to brief the anti-SLAPP issue, and then after they briefed the anti-SLAPP issue, the judge ruled that she didn't agree with David, and so I'm looking for that ruling.
Are you talking about the ruling where she denied the anti-SLAPP motion?
Yes.
Oh, I have that here. Here. What are we looking at, though?
What is it? What are we looking at? We are looking for.
This is not what I'm looking at. Sorry. Other one. My bad. I opened the wrong document, but I have it. Open. Downloads. There we go. No, not that. There we go. This is it. The motion to dismiss the order.
Yeah.
Right here on the screen.
Typing in the word presumption.
Okay.
Or just presume.
I got nothing.
Okay. This is order motion to dismiss. Okay, I can find it from there because I got it right here. Okay, got it. 1 sec. I will look it up.
Mm-hmm.
It's on 15-page decision. Procedure.
You let a medical person violate HIPAA, they would be fired. Yeah, that's true. And then Allie F said, same for psychologists. I'm a psychologist married to an attorney. Oh boy. Lots of licensing governing going on there.
Okay.
Why are you guys talking about peeps? Peeps don't discover an acid. Love me some peeps once a year. No circus peanuts, though. We're getting off topic here, guys. Just bear with us.
So, ethical violations analysis. Okay.
I like crunchy peanut butter more than smooth peanut butter. No, smooth peanut butter is way better than crunchy peanut butter.
Okay, so
crunchy peanut butter is messed up. Sorry,
on
what were you saying?
page 6, at the top of page 6.
All right.
You'll see the first full sentence. The PDJ notes that the statute provides that the movement has an initial burden. So that's the opening the door. He's got to open the door to establish a prima facie proof that the legal action was substantially motivated by a desire to deter, blah, blah, blah. The PDJ has conducted a cursory review of respondent's motion and finds that the motion is accompanied by a statement of facts and an affidavit as directed procedurally. However, before the PDJ proceeds with a substantive review of these materials for a prima facie showing, the PDJ finds that a review of the applicability of the anti-SLAPP motion must be considered first. So then we can skip that. That provides their analysis. Keep skipping it. The laws we can impose on constitutional authority is also okay. We can skip that. Rule chooses. In addition, this court provides separation of powers. Wow, this is actually more thorough than I thought. Importantly, okay, so so then if you go to 13, right above conclusion. Okay, so the PDJ understands that the court, you can keep it there, and then where I'm reading will fall into that page, right, where you are. The PDJ understands that the court favors an interpretation of legislation so as to be constitutional whenever possible. However, the PDJ finds that the ability to discipline a lawyer for behavior such that the state bar finds and the panel finds violates the court's rules is an important and necessary function in the court's disciplinary process. So basically, the PDJ says the ability to discipline lawyers is an important function of the court's process. Neither respondent Gingras's motion nor brief provide a legal analysis as to how the statute could be applied consistent with this court's existing rules with regard to a lawyer's professional obligations and duties. Instead, Mr. Gingras's brief simply seems to state that the statute supplements the court's rules rather than conflicts it. Stating that does not make it so. Given the absence of a showing, the PDJ finds that interpreting the statute as applying to attorney discipline actions would necessarily implicate constitutional questions and unduly hamper the court's constitutionally imposed duties. So I was wrong. It wasn't that he didn't even open the door. The judge opened the door for him, and then was like, it's legal arguments at this level of the game have very specific ways that they need to be addressed. And one of those ways in this context is what, like I said earlier, David is essentially saying that all of these rules are unconstitutional. However, these rules are unconstitutional in the face of the First Amendment, but he doesn't explain how they may or may not be applied so that they can be found constitutional, because that's what is required. You have to at least endeavor to find a way that the law can continue to exist, because the presumption is that we want laws to exist. So that is what is missing from this so far. David has not offered any way to square that analysis of how what he's saying, and the Arizona Supreme Court would ask him this, is basically, okay, you're saying that these laws are unconstitutional, but what would make them constitutional? What speech could be regulated? And then he's going to have to fall back onto that commercial speech bullshit argument that is not satisfactory.
Well, I would say that "Look at Me, Daddy" is probably the part that's not constitutional, like within the constitutionally protected speech. So, like, I don't know, he's going to have an uphill battle there. I think he really set himself up for failure, but I don't know.
This feels more like a Dear Journal.
A Dear Journal? What does that mean?
Like he's writing in his journal.
Oh, okay. So do you think he can bring that up now, though? He could bring that argument up now in the Supreme Court briefing or the document, or would he not be able to do that now because he already failed to do so?
No, he could do it. It's rather poor form to bring up new cases. Unless they are new and didn't exist at the time of the ruling, but he's done it here several times. And so, yes, he can bring up that argument. Okay.
Hey, thanks, Megan. I appreciate it. How's it going? I was like, what is a mug raid? And I realized it was Megan and Tug. They're being brought in. I was like, what is happening here? Hi, Megan. How are you?
I hope your back's feeling better, Megan. I listened to your stream. It was really good.
I'm not gonna lie to you. I didn't know her back was hurting. I'm sorry. I hope it's better though. I do. Okay. All right. Let's move on to 5 here. The PDJ's anti-SLAPP ruling must be reversed. The order denying petitioners anti-SLAPP rests upon the same erroneous constitutional premise discussed throughout this petition, that lawyers do not have the same or any free speech rights as non-lawyers. I feel like I've read this sentence 40 times in this document. Having concluded that attorneys possess diminished First Amendment protection because they are licensed to practice law, the PDJ further concluded that Arizona's anti-SLAPP statute could not constitutionally apply to attorney disciplinary proceedings because doing so would improperly restrict this court's authority to discipline lawyers. Both conclusions are incorrect. Arizona's anti-SLAPP statute reflects the legislature's determination that meritless governmental proceedings targeting protected speech should be dismissed at the earliest possible stage. But I feel like when I'm reading this, first of all, it's not meritless. Second, like this was a small part of their charges against him. And so I'm reading this, I'm like, you're doing so much here. But at the same time, it's like, this has nothing to do with the presenting false evidence, not correcting false testimony, that kind of thing. So like, even if the Supreme Court reversed this partial judgment, even if the Supreme Court reversed the ruling on this, he still has charges to fight, no?
Yeah, I mean, this is a very small piece of his overall battle.
Wow. Okay.
And don't forget, after all this is done, they can totally file a complaint against him for the DUI. Or excuse me, the reckless driving.
Right. Would they discipline him for reckless driving though? Did they do that? Like,
Well, I think what's so interesting about this case is that they are actually disciplining him for the facts that occurred versus what is said in the law, meaning that they're disciplining him for things that he said that didn't end up, adjudicated in any final way. So the reason I say that is because, yes, he did plead guilty to reckless driving, but if you read the police report, there's an indication that he was drinking and driving, and so you don't need proof beyond a reasonable doubt. It's not the preliminary or the whatever's happening to him now, the lawyer discipline is not a criminal court, so it doesn't need to be proven beyond a reasonable doubt. So yeah, they could.
Yeah. I kind of wonder.
Yeah, Lori Jane, he settled it. They dropped it down to reckless driving.
I think it's kind of BS that you can do that on your second DUI, but at the same time, it's like I don't know how these things are normally handled. It's been 20 years since his last DUI, so I'm not entirely surprised. I think it sucks, but I'm not entirely surprised that they didn't really pursue that. So I know a lot of people were upset about that. So.
Yeah, I mean, the fact that MAD was involved and they allowed it to plea down, it's, my opinion is that he probably had a showing of rehabilitation. Maybe he checked himself into AA, maybe, whatever David would do. Remember, he went to the doctor to try to prove that he had an eye problem.
Oh yeah, I forgot about that.
So,
I mean, I don't wish an eye problem on the guy. I'll put it that way. But at the same time, I'm kind of like, that doesn't explain your BAC.
Right.
If you're driving with a blood alcohol content or a breathalyzer score that's above the legal limit, I don't think that's because of your eyes. Unless you poured tequila in them and was just like, there's holes in here somewhere. You know what I mean?
I was drinking through my eyes today.
You had an eye wash station you like to have in the school labs, but it's just tequila pouring out of it.
Honestly, sign me up for whatever lab that is. I'm there.
Yo, that sounds disgusting. All right, let's keep moving here. I don't know if I want to read through this entire section here. It's really redundant, I feel like.
I can take over.
Okay, let's start. I left off right here on this right there.
Get in my reading mode.
Yeah. I'm sorry, did you need to cover your face for the reading mode? That's kind of counterintuitive.
I hope you guys can still hear me.
Oh, you sound like Omar now.
Okay.
No, I'm just kidding.
Arizona's anti-SLAPP statute reflects the legislature's determination that meritless governmental proceedings targeting protected speech should be dismissed at the earliest possible stage. To accomplish that purpose, the legislature expressly extended the statute beyond civil lawsuits to include any regulatory or administrative action by a state actor. Although,
just a question here on the ruling. Didn't the judge say that this was not a regular civil action? That this was kind of I forgot the term for it. But it's a unique one on its own kind type of proceeding. So it's not like a normal civil.
Yeah, I found that part of the analysis of the PDJ weak as well. I mean, I'm not an Arizona lawyer, but I do feel like this is an administrative action.
Yeah. Okay.
Let me see. Just quickly. She even calls it an action.
Mm-hmm.
Oh my gosh.
Have we in the chat while Patrick is looking that up resolved the crunchy versus smooth peanut butter debate? I feel like we have more people in here now, so I need to know. I'm gonna make a poll. Wait. Okay.
Okay. So the PDJ said the Arizona rules of Supreme Court provide that the nature of disciplinary proceedings is neither civil nor criminal, but are sui generis.
Right.
Which I believe means of their own or speak for their own.
Yeah, I think it means unique, kind of not one of a kind per se, but unique.
Yeah, no, that's exactly what it means. They're unique. You actually just stated the definition.
Okay. Cool.
Good for you. Therefore, the PDJ holds that the disciplinary action at issue would not fall within the definition of a legal action. Respondent Gingras argues that the case involves a regulatory or administrative action by a state actor. While respondent does not cite any legal authority he is relying upon for making this assumption, we shall assume it is accurate. The PDJ therefore finds that anti-SLAPP reflects the Arizona legislature's intention that the statute apply to attorney disciplinary proceedings. So they gave it to him. So, okay. So to accomplish that purpose, the legislature expressly extended the statute beyond civil suits to include, we already read that, although this new provision has never been interpreted by any Arizona Supreme Court, the plain language of the statute encompasses attorney disciplinary proceedings brought by the state bar. Did you not read the fucking whole, like, David, just...
I don't think that they did, no. But like, it kind of seems like they're not making very good points against the ruling. They're just kind of stating the opposite, which they already kind of did. Does that make sense? It's kind of like you're just repeating yourself, but they're not really making any sort of really persuasive arguments against the ruling itself.
Yeah, because I think David's like, I just need to do enough to get an oral argument. Like, and he's always said this. Like, he's the Conor McGregor of oral arguments.
McGregor of oral arguments.
The only thing he puts in his mouth is dicks.
Oh my god.
I hate this guy. Other courts, he just gives my profession such a bad name. Other courts with similar laws agree they apply to attorney. Shut the fuck up, David. The judge held it already. Let's skip it. I don't want to read it.
Well, let's go down here. PDJ, nevertheless.
No, David. That's a straw man argument. I'm not reading it.
Hold on. I want to know what it says. PGG nevertheless declined to apply the statute, reasoning that it would unduly hamper the judiciary's authority to regulate attorneys. I already read this 4 fucking times in the same document.
That's a mischaracterization of the holding. Like, that's in and of itself sanctionable.
That conclusion misapprehends both the scope of the legislature's authority and the strict constitutional limits upon the judiciary's disciplinary power. Okay, so why is this a misstatement and why is that sanctionable?
Well, it's sort of like the you make the GoFundMe to pay a Macy's bill, like and it's like like right above this conclusion is a long statement about how it's whether or not the anti-SLAPP statute applies to disciplinary proceedings. There's that long analysis about whether or not anti-SLAPP applies to disciplinary proceedings. And then the conclusion here that follows is, nevertheless, the PJ declined to apply the statute. Like, that's not, like, it's like, look over here, and then let's make this conversation, or let's make this conclusion. What?
Nothing, that's what you were saying. I was just like, oh my God, okay. These guys are just like, I feel like they're doing it all wrong.
The PDJ nevertheless declined to apply a statute. So what I'm saying here is the PDJ didn't decide not to apply the statute because the statute doesn't apply to disciplinary proceedings. But that's what this section is saying.
Greedy Gambler Slots says, just got here. Can I get a 1-minute recap on what I missed so far? I can do you better than that. It'll be about 10 seconds. Patrick says that David is the Conor McGregor of oral arguments and that he can eat some dicks.
No, but in reality, all we've done is we've gone over David's motion for special action in the Arizona Supreme Court, and I have come to the conclusion that he has not really addressed any of the substantive issues that from the PDJ's decision that should be addressed. So I'm waffling on whether or not the court even takes this.
I thought you said for sure. You thought for sure they were going to take it, like yesterday, right?
Yeah, it was before. Remember, I was like, I hadn't read this yet.
Yeah, right.
I mean, the thing is that, like, I think that this is an important enough issue that the Arizona Supreme Court may find a way to take it, but they have ample grounds not to.
Gemma L says this argument is similar to the Atlanta BBL doctor.
I don't know what that is, and I'm kind of bummed I don't.
All right, hang on. Let's see. Nothing in Arizona's anti-SLAPP statute conflicts with any rule governing attorney discipline. Okay. Rather, the statute supplements existing procedures by providing an early mechanism for dismissing proceedings that impermissibly burden constitutionally protected speech. You've kind of read that already.
Why is Bruce talking about palm oil?
I don't know. Bruce started the peanut butter thing too, I think. So, Donna Shepard, thank you for the 2 jewels. Appreciate that. Oh, and thank you for the other 2 jewels. That's cool. Thank you so much. All right. Let's see. More fundamentally, the PDJ's separation of powers analysis rests upon a flawed premise. It assumed the judiciary possesses inherent authority to discipline attorneys for constitutionally protected speech, and that the anti-SLAPP statute improperly burdens or limits that authority. Okay. Anti-SLAPP statute improperly burdens or limits that. Okay. But the Constitution defines the outer limits of every branch's authority, including the judiciary's. Is this them trying to explain how it could be constitutional at the same time?
Ooh, let's see.
Okay. Put simply, neither this court nor the state bar has the power to punish speech protected by the First Amendment or Article 2, the speak out.
I love when he tells courts what they can and can't do.
They're citing Gentile and Green, Olin. We've already read all that shit. Okay, but what's the point? What's your point? They're just citing cases here, but like...
Can I read it real quick? Can I read the paragraph above that? Sorry.
Above that, yeah. Go ahead.
Yeah. More fundamentally, what can be more fundamental than fundamental? However, God help us. The PDJ's separation of powers analysis rests upon a flawed premise. It assumes the judiciary possesses inherent authority to discipline attorneys for constitutionally protected speech, and that the anti-SLAPP statute improperly burdens or limits that authority. That is, that's pretty close. It's not wrestling. This is my problem with him always. It's not actually wrestling with the facts. Okay. But starting a sentence with, the Constitution defines the outer limits of every branch's authority. Which Constitution, David? The Arizona one? Which one? Including the judiciaries. That's a terrible sentence. Put simply, more fundamentally put simply, however, neither this court nor... He loves a good nor. I always want to use nor, but I'm like, it never makes sense. Neither this court nor the state bar has the power to punish speech protected by the First Amendment or Article 2. Yeah. Oh, okay.
People ask me to zoom in.
Yes. Okay. And then he's saying, C. Gentile, at the very least, our cases recognize that disciplinary rules governing the legal profession cannot punish activity protected by the... Okay, but this is a broad statement about the First Amendment, capital The. Not David saying, look at me, daddy, I'm a real lawyer now. Like, this is my fundamental problem. Like
this whole like, and I know there was like a blog post where he did a warning against Judge Mana and stuff, but it seems like this whole thing kind of basically stems from this ridiculous "look at me, daddy, I'm a real judge now" thing that he put in his stupid ass motion for change of judge. And I'm like, if we hadn't gone there in the first place, we probably wouldn't be here right now. But he always has to cross the line.
Yeah. So you can skip this because there's a bunch of citations to shit that doesn't matter.
Yeah, okay. That's what I thought. Okay, let's see. Because protected speech cannot support discipline, Arizona's anti-SLAPP statute does not deprive the judiciary of any legitimate or lawful power. Okay. It merely provides a procedural mechanism for promptly enforcing constitutional limitations and protections that already exist.
So that's his way of addressing how there can be harmony between the ethical rules and the anti-SLAPP statute, is to say there is no harmony. Goodbye. So he's proposing to get rid of all attorney ethics rules in the state of Arizona.
I was about to say, like, this seems like either empty words or exactly the opposite of what he's supposed to be doing. I'm very confused.
Ooh, he's citing Marbury versus Madison. Get it.
Okay. All right. As the Supreme Court recognized long ago, a law repugnant to the Constitution is void. Okay, so we're just fighting against the law in general now? I'm confused.
Yeah, I think he's basically saying the entire ethics framework in Arizona. I mean, hey, if Arizona Supreme Court throws out its own ethics laws for violating the First Amendment, like I will be applying to be a lawyer there.
Is "Look at Me, Daddy" gonna unravel the state constitution?
Exactly. Like that's the question. Honestly, Lauren, like that's the question a good lawyer reading this would ask David as the client. Like, are you saying that we have to throw out every single ethics law? And
Because
then if he says yes,
to protect your right to say "Look at me, Daddy" against your presiding judge.
yeah, if he says yes, I'd say stand in the corner with your face facing the corner until you have thought about what you've said.
Yeah. Oh my gosh. Okay. Ultimately, the anti-SLAPP issue rises or falls with the constitutional question already before this court. If attorneys retain the same constitutional protection for speech as others, the PDJ's rationale for refusing to apply Arizona's anti-SLAPP statute necessarily fails as well. Because lawyers are entitled to the same free speech protections as non-lawyers, the anti-SLAPP law does nothing more than offer an additional appropriate tool for dismissing claims which lack legal merit. The order denying petitioners' anti-SLAPP motion, therefore, should be reversed. Okay.
But can I unravel that short last paragraph? What is
yeah, go ahead. Because
lawyers are entitled to the same free speech protection as non-lawyers. Okay, he gives no legal proposition for that. The anti-SLAPP law does nothing more than offer an additional appropriate. This is the same. Oh, can you see his footnote there? 2.
Supreme Court Rule 49B already permits the dismissal of meritless claims through a variety of dispositive pleadings, including Rule 12B6. These are motions to dismiss, right?
Or irrelevant. It's irrelevant, and he's making the exact same argument he made that the PDJ threw out.
Okay, got it. All right. So this is where he's asking for reassignment. Upon granting relief, this matter should be reassigned. If this court accepts jurisdiction and grants relief, further proceedings will be required below. Under the unusual circumstances presented here, the court should order that these proceedings be assigned to a different judge. Why? In any ordinary civil action, when an appellate decision requires a new trial on one or more issues, the successful appellant's right to a change of judge is renewed. Although that rule has not been incorporated into the attorney disciplinary rules, the policy underlying it remains instructive. Okay.
Why are these circumstances unusual? That's what I don't understand.
I don't know. The only thing I can think of is that this is like a first impression thing, but at the same time, does that matter?
There is no mechanism under the Arizona judicial disciplinary proceedings to have the case assigned to another PDJ.
Okay.
So he's just basically, yep. Mm-hmm. Mm-hmm.
All right. He said it's King versus Superior Court. The court explained that after reversal and remand for a new trial, it is always possible that the trial judge may subconsciously resent the lawyer or defendant who got the judgment reversed.
David in his fifties right here.
This judge has been so patient with him, dude. Like so patient with him.
Oh, as soon as she wouldn't let him put screenshots in the pleadings, he was like,
"Oh, that's right, I forgot." And like he was using was he using like the wrong color text or something? Like he wasn't supposed to do that, or he wasn't supposed to put pictures like you said. But like, I don't know, it was something ridiculous. I don't know if the color thing was actually. I might be making that up on my brain. You know what I mean? But the court concluded the mere possibility of such a thought in the back of a trial judge's mind means that a new judge should be found. That is, of course, the reason why litigants in civil proceedings are generally entitled to an automatic change of judge following reversal and remand.
Do you think David shaves his legs?
What?
Or his arms? I feel like he's the type of guy who shaves his arms.
I don't really care about that.
I just want to know, but what's your gut instinct? Does he shave his arms?
No, I don't think so.
You don't think so? I think he does.
I'm gonna say no. But I wouldn't care if he did. So, doesn't matter. I'm really curious as to why you're thinking about that.
It just adds so much more stubble, you know? And then it's like, yeah, it's like why, like it's upkeep. And it's like,
who's asking? Patrick is.
I'm just saying, I need to maybe, I've just been spitballing ideas.
Yeah, right. Mary Smith, 4002, thank you for the 1,500 joules. I appreciate that. Hellville, hey, how's it going? Thank you for the 100 joules. And Donna Shepard, thank you for the 2 joules. Appreciate that, guys. All right, let's see. Aside from the shaving arm things, I think we're going to move on here. Those considerations favor reassignment. The PDJ has twice expressly rejected petitioners' constitutional arguments and held attorneys possess diminished protection for speech simply because they are licensed to practice law. If this court grants relief, it will necessarily reject the legal premise upon which those rulings rested. Okay. Reassignment would permit the remaining proceedings to occur without requiring the same judicial officer to accept a constitutional position she has previously rejected and reaffirmed.
That's basically saying the PDJ is incapable of applying the law because that is the stupidest thing I've ever heard. I mean, I get why he has to make the argument because there's no legal mechanism for him to like demand it, and so he's got to like find a way to make the point. And I am a proponent of manscaping. I'm not saying that I'm not a proponent of manscaping. I was just thinking about how he had that one selfie that he took at the gym with like, he did like how the girls do with like the one leg in front, and he was like made like the duck face. Mm-hmm. That just kind of reminds me of like this filing is like, it's like a David like felt cute might delete selfie.
Mm-hmm. All right, then. Omar says you've never lived until you manscape your pits.
Oh, man. The moment I have money for it, I'm lasering all this toe hair off.
Oh, my God. You guys are freaks. Okay. Reassignment would also impose no meaningful duplication of efforts. The bar moved for judgment on the pleadings only 3 days after petitioner filed his answer. The PDJ resolved the principal liability issues before discovery, an evidentiary hearing, or substantial factual development occurred. A successor judge, therefore, would not be required to repeat a trial, reassess witness credibility, or master an extensive evidentiary record, since none of these things occurred previously. Petitioner does not contend that reassignment is necessary as a sanction or because the PDJ acted in bad faith. Rather, reassignment is appropriate to preserve confidence in the fairness of the proceedings following reversal, while imposing virtually no countervailing burden. If this court grants relief, it should direct that all further proceedings be assigned to a different judge.
Okay, I just want to point out that the amount of paper filed in this case, because what he didn't address is the fact that the PDJ has the most knowledge of the facts underlying this case, like the procedural history, like the substantive history, like 1, 2, 3, 4, 6, 7, 8, 9, 10. I'm not even into April of 2025, and I'm over 50 different filings. So, I mean, that's a wild argument to ask. And the fact, like, this is the short-sightedness of it all. You're asking for something that you don't have a legal mechanism to enforce, and your position on it is weak. So let's play this out logically, David. It's going to get denied, and then the judge is going to see this anyway. And so it's like, I'd always tell my business clients this, like, yeah, you may be really mad that you lost that contract, but if you go and you protest the fact that you lost it, you're going to piss them off even more. So just shut up.
Yeah. All right. We finally made it to the last section here, guys. It says, conclusion, this case presents a single fundamental constitutional question, whether attorneys surrender the protections of First Amendment in order to Section 6, which is the speak freely, whatever, of the Arizona Constitution by seeking a license to practice law. The presiding disciplinary judge answered that question in the affirmative. As numerous courts outside Arizona have recognized, that conclusion cannot be reconciled with controlling precedent from the United States Supreme Court, which has repeatedly and directly rejected the PDJ's and state bar's position. This court should follow suit and reach the same conclusion. Lawyers do not waive their constitutional freedoms simply because they are lawyers. Because the PDJ's erroneous constitutional premise permeated each of the challenge rulings, the orders granting partial judgment on the pleadings and denying petitioner's anti-SLAPP motion should be reversed. The court should accept special action jurisdiction, vacate those orders, direct the matter, proceed under the proper constitutional standards, and remand for further proceedings before a different judicial officer. Okay, and this was signed 5 days ago by Mark Randazza. So, question: say this doesn't work out, and he has alluded before that he would take this to the United States Supreme Court. He thinks this is a dream case it could go that far. What happens if they deny him, even if they go to like oral argument and stuff? If they deny him in the state Supreme Court, then does he move to the Supreme Court to try to get that overturned? Is that what happens?
Yeah, I think he'd actually have to go to federal court, I believe. I'm not, obviously it's a very complicated area of law, like Supreme Court practice, but just my guess, I guess I would call it a guess, would be if it got denied, then he'd petition for a writ of mandamus, I think it's called, to the federal court, the federal district court of Arizona. And then he would, if he lost that, then he could go to the Ninth Circuit. And if he lost that, he could go to the, there's, a lot of machinations between there. He could go to the Supreme Court. But what I find, what I think realistically will happen will be that it'll get remanded on some specific issues to, for the PDJ, and the PDJ won't get reassigned. The PDJ to like clean up some issues. And I think that that's like proper, again, this is just all speculation, but I think the way the PDJ played this, which is pretty smart, was I'm going to make a broad decision here, knowing that this Yahoo is going to appeal it. And then the Supreme Court will probably give me guidance on the things that I am not sure about, and then I'll take that guidance and I'll reapply it to a new analysis, and then issue a new decision. And even in that context, he can still appeal that by special action.
So
that
this
would be
go
like
on for like fucking ever, basically,
until he runs out of money. Yeah.
I mean, I want to say, like, Mark is his friend, man, right? So, like, I don't know if Mark would even charge him for that. Like, you know what I mean? Like, so.
The thing is that, like, lawyers are, at least Mark is a managing partner, so no matter how good of a friend you are, like, bandwidth is bandwidth. So,
yeah,
and you have to basically ask yourself, like, you're running a business at the end of the day, not a Jan business where, you have more losses and therefore no gross income, but he's running like actually a pretty successful business. So, at some point you got to say, listen, man, this horse is not a winning horse for me. Like it's costing me, because what I think is really happening is that I think David is drafting most of this himself. And Randazza is, lightly touching it. So I think that the overhead for Randazza is probably pretty low here. So yeah. I think that's what'll end up happening.
Yeah. All right. Somebody asked, Patrick, do you dream of winning a precedent-setting case in the Supreme Court like Neidigh?
I really aspirationally, where I'm at in my career right now is, I really would like to join the federal government, like join the Department of Justice, whenever like a Democratic administration comes to power, and really focus on trying to tie up some of these loose ends that we've seen exploited in the judicial system by the current administration and the current DOJ. So that's really where I see myself. I don't think I have the stamina to be a trial attorney, to be totally honest. I just don't think I do. And so no, I would not. I really wouldn't care. I would like to clerk for a Supreme Court justice. Like I'd love to clerk for Sotomayor. I thought about that. That might be another thing that I consider doing. Obviously these are things that less than 1% of anyone in the world gets to do, but that would be something cool to do.
Danny says, if Randazza actually wrote this stuff, he's not the skilled lawyer I've heard him to be. Well, I think Patrick kind of pointed out he thinks David's doing most of the heavy lifting on this, but yeah. I mean, I don't know what's happening behind the scenes there. I have no idea. So
for someone who is as prolific at tweeting as Randazza is, he hasn't made a comment one way or the other about it. So that's surprising.
He's so prolific at tweeting. You could have been talking about either one of these guys, but I guess David's not online so much these days, which I think is good for him, obviously. So
yeah, I'm gonna see. Did he unlock the case write-up?
I don't know. You can check it out.
I'm happy to answer any more legal questions people have about the case.
Thank you, Ricky. Appreciate that. Sorry, what's that?
I'm happy to answer any more questions people have about the case.
Oh yeah. Does anyone else have any questions for Patrick? I know that somebody asked Omar if he was pro toe hair or something. Omar, are you pro or con toe hair? As it pertains to feet, I'm fundamentally against. Wait. Okay.
I mean, there comes a point in your mid-30s when you're just like, this is my body, and I guess I have to live with it. So
I did that 10 years ago, like 23. So I don't even fucking care.
oh my God. Wait. It's doing it again. It's linking
What?
to echoes again.
What?
Okay. Shit, I can't share my screen because I can't show
You
you.
can.
I can't. I'm here. Just click on this link.
Okay. You put it in the private chat?
Oh,
put it in the private chat because I can't click on that. It won't let me. Oh, wait, no, I can. I can just go to the regular YouTube chat. One sec.
okay. So if you click on that.
Smooth wins, by the way, 66 to 34%, guys. I'm ending the poll. All right, I'm clicking on the link here. Hold on. Search results for Gingras. Hang on, let me move my head here.
Well, you're not sharing your screen though. Okay, good. Yeah. So click on that. Click on the more. Yeah, read more.
Oh my God. There we go. Okay. I'm gonna close this real quick. Read more, you said.
Yeah, click on it.
Laura Owens lawyer David Gingras war on the AZ bar. Mark Randazza enters. Read more. And then it just takes you to echoes at the tabernacle.
It's not showing up on your screen, but yeah, it is.
Wait, I'm sorry. Hang on. This is what it took me to.
What the fuck?
Wait, why are you advertising this? Doesn't he complain about echoes? Yeah, he does.
See, I told you I'm not a liar. Okay.
No, I didn't think you were a liar. That's just really weird.
What do you think is going to ultimately happen in the bankruptcy case? Ooh. I'm happy to weigh in on that after this. Yeah, that's what I was saying, Echoes. Like, get those clicks, boy.
Yeah.
You need to put like a creator link or something.
Oh my God, no! You should ask him to plug your Venmo or something. Like, come on, man. I'm advertising for you. You should send him a quote for advertising fees or something.
Yeah, honestly, copyright infringement. No, I actually don't know if that's copyright infringement.
It's a redirect to his channel, so it's not copyright.
Totally made that up. It just makes. Why is it hyperlinked to that?
H. Murr, thank you for the $5. Patrick, what's your opinion on the legal distinction of the bar versus a traditional employer in terms of firing ability?
I first want to just quickly mention what MDD asked about the Owens bankruptcy case. I believe the fact that they canceled the 2004 hearing is an indication that it's getting converted to Chapter 7. So liquidate. Okay.
What does that mean? We go to Chapter 7. Like, so.
Honestly, I'm on the same roller coaster y'all are in. I didn't know what the hell Chapter 13 was. Then I did. I didn't know what Chapter 11 was. Now I did. Well, I'm sorry, but I missed the other. Oh, yeah,
H. Murr, thank you for the $5 again. Patrick, what's your opinion on the legal distinction of the bar versus a traditional employer in terms of firing ability?
Well, the bar can't fire you. They can disbar you. Versus a traditional employer in terms of firing. I would say a traditional employer can fire you much, much easier than the bar can disbar you. Okay. Because think about it, a traditional employer, you can get fired and then really you're only left to like the alleged discrimination, and typically there's an administrative process for that and the presumption is against you, versus in attorney discipline you have a full, Arizona has incredible due process protections for lawyers. Like, it's really impressive. So I would say, yeah, I hope that answers your question.
I think about it this way, like when you are answering to a licensing board, they take your license away. It's not like you lose your job, you can go to another firm. It's not like if you're a doctor and the American Medical Association takes away your license, you can't go to another practice. You can't start a practice. You can't work at another hospital. You're done. You're blacklisted. Over. Your life is essentially, your professional life is essentially over. You have to find something else to do with your life. So like it's different than getting fired by, like, say, if my employer fired me, I don't know why they would, because I do a really good job. Thank you. But if they fired me, I would go find another job doing something similar. You know what I mean? I could do that easily. But if I had a license and I messed up to the extent that it violated the ethical standards of my profession, like say I was a therapist or something, like the rest of my family they're all licensed psychologists, therapists, whatever. If they were to do something that violated ethical standards and they their license was taken away, they couldn't be a therapist anymore. You can't be a psychologist anymore or a doctor anymore. You have to find something else to do. I don't know what you would do at that point. So
yeah, actually, I remember in Florida, your guys's whatever like the head doctor is called, Surgeon General. Your Surgeon General was like not licensed to practice in Florida, but was like appointed Surgeon General.
Wait, why did I not know that?
This was a long time. This was like when Ron DeSantis was wearing his boots with lifts in them. It was a while ago.
Ron DeSantis has boots with lifts?
I mean, I'm really glad you're not politically engaged, but yes, he did have.
I'm really not, dude.
Yeah.
Like, I am, but I'm not at the same time.
Google Ron DeSantis lifts.
I will, but I'm so politically moderate that I like don't hear these things. Because I'm like I don't fall on one side of the aisle, so I don't get the shit posts from the right or the left because I'm like so down the center. So I miss out on all this meme-worthy stuff.
I was born and raised in a libertarian state, so I've just always believed like believe what you want to believe politically. You know, I can still be your friend. Like, let's just not fucking talk about it.
I agree.
And now now it's like people's identity is like who they vote for, and it's just it's too bad.
I just can't get wrapped up in that too much. So, hey Ducky, sorry you came in just at the end here, but I think that's all I got for tonight, guys. I went a lot longer, like an hour longer than I thought I was going to go. So thank you, Patrick, for sticking it out. Appreciate that. Yeah. I didn't mean to keep you here for 2 hours, but yeah.
Yeah, I'm really happy that we were able to go through this. I'm glad that we gave it the attention it deserved.
Yeah.
Which is not much.
Yeah, okay. Fair enough. I mean, there were conversations about toes and stuff in the middle of that. So, yeah. Peanut butter, peeps.
I'm a smooth guy. I'm a smooth guy.
One more here. Rach G, thank you for the $10.
No, I'm happy to answer any questions as long as they're coming in and paying you.
Yeah. Oh, dude.
No, I'm just fucking with you.
I almost lost my license to pass medications because my sister was at work and fed someone pudding. Someone reported to management she was passing narcotics for me out of revenge. Whoa. Wow. That's crazy. And I'm glad that it was an almost and not you didn't actually lose your license. That would have been terrible. So
yeah, like in that case in like Arizona, they would have done like a preliminary investigation, and then a lot of the preliminary investigations, even to David himself, were dismissed, right? Like Dave Neal submitted a complaint that was dismissed. So there are a lot of due process protections. David saying that he's getting bullied on and singled out is, it's just more Jan rhetoric. Like the fact of the matter is, yes, there are lots of unethical lawyers. Fact of the matter is, yes, there are a lot of unethical old people with LLCs that they're using to do shady shit. Like there's a lot of fraudulent GoFundMes. The overriding principle here is that they got caught. And so typically when you get caught, it's fight or flight.
Yeah.
And if you're going to fight, you got to do it the right way. Like you got to be on your P's and Q's, and you got to like Jan could have made the bankruptcy go away. She could have given a full accounting of how the GoFundMe was spent and admitted to all of her wrongs, and things would go better for her.
Yeah, you're right. But I mean, this family rarely does anything practical. So
that's why David and them are twin flames.
Yeah, for sure. All right, guys, I'm going to send you over to my friend, the expert. Actually, Zach, Prince of Wales, thank you for the $2. Says, want to raid the expert. I was just about to send you guys over there. So yes, the answer is yes. All right, thanks everybody. And thank you, Patrick, for hanging out with us. Don't forget to hit the like button on this stream for me. It helps me out a lot in terms of visibility. And I will see you guys sometime soon, I'm sure. All right. Thanks, everyone.
Bye all.
Bye.